Good afternoon, everyone. How are you today? Great. Thank you all so much for coming out, especially with everything that's going on. Makes me know this is important to you. So I hope what you learned today will be worth the effort. I'm sure that it will. My name is John Murphy. The name of my law firm is Safe Harbor Wills and Trust. You met most of my team checking in here today. One of the members is off taking children to college, Tammy, who runs our Medicaid office. We are right around the corner. So we're over on Buckley Road. This is our office, 6702, right across from the Comfort Inn. Right? Easy to get to. Everything we've done has been with the client in mind. You don't have to go downtown and struggle to find parking and worry about the meter. If everyone would turn off your cell phones or at least put them on vibrate, that would be very welcome. The other thing is everybody should have a name tag, if you can make sure you have that on. So if you have a question for me, I'll know your name. Fair enough, because you guys know mine? Okay. Everybody should have a couple of items. You should have a evaluation form that looks like this. Name and address should be on it. Make sure your name and address are correct. We're going to ask you to fill this out when we're done. If you want to get a head start, just give me really great grades right now. Okay? But we take this feedback very seriously. So if there's something you like, let us know. If there's something that you didn't like or we could do better, please let us know. Some of you may or may not have been impacted. We had a website problem. Our website crashed on Friday or Monday. It's back up today, but so that may have been an issue, but that was a technical glitch that we take care of. Okay. Everybody should have a notebook that looks like this. Yes? Okay. We're gonna work with that through the workshop once we get going. Okay. So I want to tell you a little bit about me and how I started doing this. I didn't always do this area of law. I used to have a general practice law firm in my hometown of Phoenix, just up the road, and did a little bit of everything: real estate, personal injury, divorces, custody, child support, tickets, misdemeanors, felonies, appeals. And then something happened to these folks right around the turn of the century. They were Bob and Catherine. They were my wife's grandparents. And Catherine went into a nursing home over in Baldwinsville, Syracuse Home, fantastic facility. And so Bob went to his local attorney, who was a general practitioner like I used to be, and said, "What can we do? I'm worried about losing all of our money to nursing home." And so they drafted a will, because after all, Catherine was sick. She was in a nursing home. Bob was still making furniture. Okay? He made chairs, he made dressers, he made clocks, cabinets. And Catherine had not been well for a while. So the attorney drafted a will that disinherited Catherine. Okay? And when you're a general practitioner, you tend to do things on the surface that you've always done without really looking down below the surface to see what's going on. Okay, you ever see the picture of the iceberg, right? There's only 10% of the iceberg is above sea level. Okay? Or the duck that's going along smoothly, but all that other stuff is under the water. So one of the assumptions the attorney made based on all the circumstances, well, Bob's going to outlive Catherine. After all, Catherine's in a nursing home. That's mistake number one. You can't ever assume anybody's going to outlive anybody. Right? And number two, they didn't ask Bob how he and Catherine owned his stuff. And number three, either he didn't think about it or didn't think it would be an issue. You can't totally disinherit your spouse with a will. The law prohibits it. The spouse is entitled to 1/3. I see that. And that's because, when you go back to the day of Mad Men, remember the TV show? The faithful secretary would always inherit. And that was back in the day when everything was in the husband's name, because women traditionally didn't work, right? And they couldn't own things in their own name because they didn't have credit. So anyways, what happened was what usually happens when your name is Murphy, right? Anything that can go wrong will go wrong. Right? Future lawyer Tanya, I know all about you, Tanya. Congratulations. Yeah, what year are you, Tanya? Second year law student here at Syracuse, I'm assuming, right? Congratulations. You made it through the first year. So Everything else is easy. Yeah. When we're not in front of people who might become clients of mine, I'll tell you what I did for my last 2 years in law school. Okay. So Bob died first. Okay. And the family came to me, my mother-in-law, I was still newly married relatively, and I was still afraid of her, okay? And she said, John, can you help get Mom on Medicaid? Because I didn't realize this was costing this much. I said, sure, how tough can Medicaid be, okay? Because in my practice, I had sued Suzuki successfully. I had sued Zurich American Insurance Company successfully, had a number of appeals that established law in our area. How tough can Medicaid be? Well, I got into it, and I soon realized I had no idea what I was doing. None. Things I knew to be true in the real world were not true in the Medicaid world. And I had to humble myself and tell my mother-in-law and my wife that I can't help you. Okay? Now, when general practitioners bring in a case, maybe I got to learn along the way. Okay, I'll learn on the client's case. This was my family. I couldn't do that. So I had to find an attorney that did this stuff. And I did, and Catherine wound up losing about half of everything she and Bob had spent a lifetime for. Not because of anything I did or didn't do. That's just kind of the state of the law. If you haven't done anything and you go in a nursing home, you're probably going to lose about half. Maybe more, maybe less, depending on certain circumstances. Okay? So I then created Safe Harbor Wills and Trusts. Our name tells you what we do. I don't do family law. I don't do divorces. I don't do real estate closings. I don't do criminal law. The only traffic tickets I do are for my kids. Okay? And our mission is to help you, right? Number one, we help you protect your family, protect your future, protect your legacy. You have to be the driver in this. We're just here to guide you along your choices and what you can do. And when we get to the end today, we're going to take you down a decision tree where you're going to be able to take what you learned today and pick out the right plan for you and your family. It's not the same plan for everybody. So I love doing these workshops. We haven't been able to do them for about 6 months, but I also teach and I write. These are some of the texts that we've written for folks to teach other lawyers and financial planners and CPAs that have to get credit to stay up on things. So this is my favorite part of what we do. And what we found out is the people's biggest risk to protecting their stuff from long-term care is procrastination. Right? It's not doing something. How many people think that they probably should have done something a year or 2, 5 years ago? And they're just getting around to it, right? Okay. So what we have done is said, listen, for coming to today's workshop, we're going to give you a free appointment to come in and talk with one of my case managers who I've trained, right? You're going to learn from me for 2 hours. You're going to pick your plan. They're going to onboard you if you're ready to get onboarded, and we'll get moving along with the process. This is free. It expires in 30 days because then most of what you hadn't managed to get out of your head before you walked out those doors will probably leave your mind before then anyways. The other thing we're doing, and this came about a little bit accidentally, we have clients in an annual maintenance plan, for lack of a better term. Okay? Voluntary, but we have about 200 folks in it. And we couldn't do our annual meetings this year where we buy them lunch, we bring them up to date on things, what's going on in the world, provide some entertainment. So we have offices here in Syracuse and also in Watertown. So what we did is we bought 100 meals at Meals on Wheels and 100 meals with the Jefferson County Office of the Aging for home delivery and home nutrition programs for people who aren't as fortunate as we are and who need those services. And our clients loved it. Okay, we told them, we said, listen, we didn't have our lunch, but we're buying lunch for all these other people. And they thought that was great. So what we're doing today, just for showing up at your appointment within the next 30 days, we're going to donate $25 for either Meals on Wheels or the local food pantry. Okay, you'll be able to make that choice. My team got a great lift out of helping folks. We got some nice letters, but we know we were able to help a lot of people. We bought about 100 meals at each of those places. Okay? And people are really struggling now. So the more we can help, the better we are. So procrastination, let's not procrastinate. All right, so the front of your book. Everybody look at the front of your book, okay? Anybody remember that picture? Yes, no? About 3 years ago? Anybody know the story? This is the Sand Castle, that's what the folks named it, on Mexico Beach in Florida. Hurricane Michael came through, I think, 3 years ago, and as you can tell, this is pretty much the only house standing in the path of the hurricane, other than the one behind it that was sheltered a little bit. Anybody know the story behind why this is standing? Florida had a hurricane building code. All these other houses were built to the code of the hurricane building code. The owner said, no, that's not good enough for us. This is our family legacy. I want my kids and my grandkids to be able to go here. We're going to go above and beyond the building code. We're going to do more than is required. We're going to do more than the neighbors. It cost them about, I think they said, twice as much to build it. But they said we wanted it to be standing when the big one came. And it was. We think that's a terrific analogy. You can do what your neighbors have done, what your parents have done, and get that $200, $300, $400 will. But when the big one for senior citizens, which is long-term care, comes along, you're going to be wiped out. Okay? We're going to show you why wills don't protect your stuff. So that's why that's on the front cover. And I actually took the whole exact story and put it, I think, on the inside front cover. All right? So, how many folks are here today because you're worried about paying for a nursing home? Or a loved one paying for a nursing home? Okay. How many of you have a plan to pay for the nursing home? Oh, you're wrong. Everybody has a plan for paying for the nursing home. There is a default in everything. Okay? What's the default? Well, anybody got private long-term care insurance? One. So one of you has a plan. Two of you have a plan. Okay? Everybody else, you have to private pay. That's your plan. I don't have insurance. I haven't protected my assets. My plan, whether I know it or not, is I'm going to pay the nursing home bill. Does that make sense? If you haven't done something else, then the default is you have to pay. Now, there are some other benefits out there that can help you pay. Veterans, any veterans here? I know we have one. Thank you all for your service. Depending upon when you served, where you served, how long you served, there may or may not be veterans benefits. Okay? I just learned a new one. We have a client from up north who's Akwesasne. He's a member of the tribe, and they have a nursing facility, but it's in Quebec. And his wife said, you're not going to Quebec in a nursing home. But he can travel to Canada without any problems, even with COVID. So, all right. Everybody else, once you run out of money, you're going to let the government pay, which is called Medicaid. Okay? So we're going to tell you how far down you have to spend your money before you can get Medicaid. But eventually, if you're in a nursing home long enough, almost everyone winds up on Medicaid. So what is the risk of needing long-term care? Well, once you hit age 65, it's about 70% that you're going to need some type of nursing home service at some time. It might just be I have a hip or knee replacement and I have to go in for rehab. That's in a nursing home. But Medicare only pays the first 20 days, and then they only pay 80% of the next 80 days. And if you're there longer, you're stuck. Or some folks don't have enough money coming in every month to pay that other 20%, and they would like some assistance. The stereotypical thing that happens, particularly for people who are widowed or single, is they're in a nursing home, they don't get out of bed enough, they get pneumonia, they become weak, and the nursing home says you can't go home. And then the kids come to my office and they don't ask, can you help get mom out of the nursing home? They ask, how much can you protect from Medicaid? Because they're living their lives or they're out of state or whatever it might be. Well, I got a pretty good chance of needing a nursing home, but really what's the cost, John? Well, nursing homes are about $400 a day or more in central New York. The Nottingham, I think, is about $600 or $650. So that's $12,000 a month, $144,000 a year. So right now your plan is the first year of a nursing home, I'm going to spend $144,000. Somebody broke it down for me. It's actually about $15 an hour because you're there 24 hours a day, right? Okay. The average stay is 30 months. It's not like you're going to be there for 3 months on average. The average stay is 30 months. But 20% of people are there for 5 years or more. We had a gentleman that became a client after another attorney. His wife was on Medicaid, but every year with Medicaid you have to refile. And so he became our client, and his wife was in a nursing home. She had a 6-month life expectancy when she went in. She lasted 8 years. He said, I can't even pronounce the disease. It's like 2 13-letter words. I don't know what it is. But because nursing homes do a very good job at keeping you alive. So 30 months at $12,000 a month is $360,000. All right. Now, if you have a cognitive disability, Alzheimer's, dementia, the average stay is about 8 years because you're usually otherwise healthy, right? Your body's healthy, it's just your mind that's not healthy. So that comes out to about $1.15 million if you were to pay for it yourself. So whenever I run these numbers, people say, oh, what about long-term care insurance? So we got a couple people here who have it. What I would ask you to do before your appointments, if you'd call your companies, got a pen? Okay. I want to know how long the insurance is good for. What's the term that it's going to pay? 3 years, 4 years, 5 years, okay? What's the daily benefit? How much do they pay every day? And is there an inflation rider? And lastly, is it a New York State partnership plan? Okay, because New York State partnership plans are a little bit different than most long-term care. Okay? And you can keep notes right in your book. There's pages where you can keep notes in your book, so if you guys follow along. All right, long-term care insurance, things to know. 50% of long-term care policies are never used. People die before they need them. Which, if you really dig down into it, they never went to a nursing home because in order to get long-term care, you got to be pretty healthy. They don't give it to people who are sick. Okay? Now, 65% of the 50% that are used are not used until the client is between 80 and 89 years old. Okay? So I'm going to use 85 years of age in an example coming up, but I just want you guys to know where I got that from. I didn't just make it up. Most long-term care policies have an elimination period of 90 days. Think of that as a deductible. You have to pay the first 90 days that you're in the nursing home before the policy will start paying. Why do they have that? They're hoping you'll die, right? They don't have to pay it. Okay, this is an actual quote that we got from a client after they came to a workshop. I encourage everybody to get a quote. Let's know what the numbers are. Let's not assume it's just too expensive. Okay? She was 67 when she got this quote. Okay? The benefit period is 3.1, 3 and 3 years. The daily benefit is $250, $250 or $200. She got 3 quotes. 90-day elimination period. Okay? So, let's go through an example here. And here's the cost down here, as you can see. $5,700 a year, $8,500 a year, $6,100 a year, about $6,200. Okay? Anywhere from half to 3/4 of the cost of 1 month in a nursing home. Every year. So, the length of coverage was 3 years. Maximum coverage is $250 a day. Anybody see a problem? Right? Doesn't cover our $400 a day, does it? So that's why for you guys, I want to know what's the daily benefit. Okay? Elimination period is 90 days. They have to pay for the first 90 days. The cheapest premium was $57.24. Now, this client happened to make about $3,000 a month in personal income. Social Security and a small pension that she had. So, assume that she needs long-term care at age 85. That was 18 years from the date of the quote. Okay, and we're going to use a $5,700 round numbers for the premium example. Okay, 90 days. She's got to pay the first 90 days, which is $36,000. Then she will have paid premiums for 18 years at $5,700. That's $102,600. None of that accounts for increases in premium rates or increases in nursing home rates. So before she can ever use her policy, it's going to cost her $138,600 out of pocket. Everybody know what the term opportunity cost is? Means the money she lost because she couldn't invest that money, which is really not calculable, right? At least not by me. I mean, there are people who could do that. Long-term care didn't even cover the cost. You guys already caught on to this. We're short $150 a day, which is $4,500. She only makes $3,000, so she is short by $1,500 a day. She has to do one of two things. She either has to spend her own money out of her savings, or if her savings are at a level which will allow her to qualify for Medicaid, get on Medicaid. So it's $138,000 out of pocket, and she's still going to lose $1,500 a month, which times 30 months is what, $45,000 that she has to pay. Okay. Now, if she's there longer than 3 years, and the insurance stops paying, she's got to pay the full shot. Okay. So, any questions on that? Because now we're going to talk about Medicaid, qualifying for Medicaid. Okay. All right. So, I used to do about an hour in my workshop on Medicaid and show you how much Medicaid stuff I know. And then we got some complaints because people found themselves really groggy when they're driving home after listening to me for an hour. All right. So, what I've done is boiled this down to a single person who wants Medicaid assistance for the nursing home, because that's really our biggest risk. If a couple's married and one of the spouses is in the nursing home and another spouse is at home, there's all kinds of stuff that the spouse at home gets to keep. The house is safe, and at least $90,000 of other assets are safe. But the huge risk is, what if your spouse at home dies first, which happens about 2/3 of the time, because they've worn themselves out keeping you out of a nursing home, and they're guilty because you're in a nursing home, and they're all alone trying to take care of a house by themselves. Okay, so about 2/3 of the time, the spouse who is the well spouse dies first. Then, when they die, who here has a will? What does your will say? Those of you who are married, I leave everything to my spouse who's in a nursing home, right? Okay? So, we're just concentrating the numbers because it's easier to understand for a single person. Okay? So, one of the complaints we hear about getting on Medicaid is, John, I don't want to be treated like a Medicaid patient. I want to be treated like a private pay patient. Two things. Okay? Marie used to visit people in nursing homes as part of a mission that she was involved with Hope for the Bereaved and through her church. So that's why she's laughing. Marie, when you go in a nursing home, do you know who's paying private pay or Medicaid? Yeah, there's not a big scarlet M on the door if it's Medicaid, right? The people doing the caring, they don't know. The only people who know are the people in the business office. Plus, it's illegal to treat Medicaid payers different than private payers. Okay, this is the federal law, but also under state law. And I joke, but in reality, I know how hard people in nursing homes work, and they're understaffed and overworked, and they're generally underpaid because they don't have skills or education, which is why they're doing that job in the first place. But anyways, where was I going? You will be just as poorly cared for if you're private paying as if you are having Medicaid assistance. I promise you. Okay? So, the first question Medicaid is going to ask when you file the Medicaid application is, how much money do you have now? Okay. And how much money did you have in the last 5 years? This is the famed 5-year look-back period. So what happens is the 5-year look-back does not officially start until you are A, in a nursing home, and B, you ask for Medicaid assistance. Medicaid's not running around saying, Hal, what have you done with your money this year? Right? Because you're not asking them for help, so they don't care what Hal did with his money. Okay? When you ask for help, you have invited them in to follow the Medicaid rules and to ask what you did with your money the last 5 years. So, in essence, you control the 5-year look-back period by when you apply for Medicaid. One of the rules we tried to teach nursing homes, we actually had a official for Nescentia Home Care here today to learn this, is you should never apply for Medicaid unless you're qualified for Medicaid. If you apply and you have too much money, Medicaid is going to require you to spend all of that money on your care before they'll give you assistance. What we do for folks already in a nursing home is we help align their money and shelter their money so we can get you assistance much sooner and still save maybe half. Okay? But if you just apply right away, you're going to lose everything. Okay? So what's Medicaid going to look at? Okay. Oh, I forgot this. Community Medicaid. New York State has a really great program. It's not as great as it used to be, called Community Medicaid. That will pay to keep you out of a nursing home. Anybody ever seen the PACE vans going around, right? Nescentia also does home care. There, until October 1st, there was not a look-back period. So if we had somebody come into our office today, Mom's got a house and $100,000, we want to get her on PACE, we would transfer the house and the $100,000 this month. She'd be eligible for Community Medicaid September 1st. There was no look-back period for Community Medicaid. Starting October 1st, there's now a 30-month look-back period. Okay? So if anybody has a loved one or somebody you think needs care to stay at home and they have assets, please see Hannah or Ann. Will you be out there, Ann? And move your appointment up to next week. We reserve, in the week following our workshops, some crisis appointments, because particularly in this case now, 1 month time could cost you tens of thousands of dollars. So if you have that situation, please see one of the team members at the break. Okay. So another thing to remember when we're talking about protecting our assets, and we're going to talk about wills, revocable trust, irrevocable trust. The cardinal rule of asset protection is if you can get your hands on your money, then your creditors can get their hands on your money. If you can get it, they can get it. Which makes sense, right? If I have the right to use and spend my money how I want to, and I owe somebody some money, well, I shouldn't be able to shelter it and not give it to them if I owe them the money. Okay, so if you can get it, they can get it. So, Medicaid, single person, income on the left. This is the money that comes from somebody else. Social Security, pension, required minimum distributions from your retirement accounts, rents, interest income, annuity payments, if you're getting annuity payments. And on the right is assets. That's what you have saved over a lifetime. Single person gets to keep $15,750. Okay? An irrevocable funeral and a car. Essentially, all other assets have to be spent down till you hit $15,750. You have more than that and you apply for Medicaid, you're going to lose it. So we had a client up in Alexandria Bay came to see us, and I'm going to talk about IRAs right now. Also applies to 401ks, 403bs, 457s, all those things. Okay. She was 62, I believe. Husband was 67, 68. He had dementia. Wanted to get home care. So she applied for Medicaid services. They turned her down because she had too much money, and she didn't understand why. Here's why. She had an IRA worth, let's say, $150,000. Now, IRAs, 401ks, all those things, when I say IRA, I mean all of those, fall into either of these categories for Medicaid. They are either income or resources. They're one or the other, they're not both. Okay? In New York, this is a very unique, like New York and Florida Medicaid law. Because she was under 70 and a half, and because she was not taking regular distributions from her IRA, Medicaid says that is an asset. And you have too much money for your husband to get Medicaid. Okay? If she had been 70 and a half and was taking required minimum distributions, Medicaid would have ignored the IRA because now it would have been in the income column. Right? So New York, once you're taking required minimum distributions, they ignore your retirement accounts. You get to keep those, you just have to take those regular distributions that you're required to take, and that becomes part of the income calculation. So we were able to fix the problem for her in about 2-3 weeks, got her husband on Medicaid. Now, unfortunately, he's in a nursing home, but got Medicaid, protected all our money. Okay. So we concentrate the workshop on protecting your home, but it really also talks about all your other non-retirement benefits. It's just kind of easy to focus on the home and go through a 2-hour workshop. All right? I could probably teach a semester's worth of stuff on this, although I don't volunteer to. And this is, for a lot of people, the thing that's most important to them to protect. I want to protect my home. I want the kids to have the home. All right? And it's one of your 2 biggest investments for most people. The 2 biggest for most people are the retirement accounts and the home. So how do we protect the home? Well, there's a common way to do it, a simple way, and a way that often winds up causing trouble. Mom and dad gift the house to the son or daughter or both, reserving life use, right? Anybody heard of anybody doing this? I'm going to give my house to my kids. I've got life use, they can't kick me out, and I get my star exemption. Anybody heard of anybody doing that? Yes, no? Yeah, we hate that. Okay? We've done it when the time is right. But why do we not like it? Because of exactly what H.L. Mencken said. Okay? For every complex problem, there's an answer that's clear, simple, and wrong. Okay? You ever heard haste makes waste? Right? Why do people do it? Because it's easy to understand, it costs less money, right? And it's simple. I go into the lawyer's office, we sign the deed, boom, done. So first issue is now you've given up control of your house. If you want to sell it, it's not your choice. If you want to refinance it, it's not solely your choice. Okay? Your kids have to agree. My kids would never not agree with me. How many of you have married children? How many of you have a daughter-in-law who's had an eye on your house? We had somebody came to a workshop and said, this happened to a friend of mine, gave her house to her daughter, wanted to sell it so she could move into a retirement community, and daughter said, no, we're going to live there after you die. And there's a very famous case in my circles when I first started this, was a woman gave house to her daughter, did not reserve life use. Her daughter and husband evicted her. Okay? You'll never know all the damage you did to your kids until they have control over you. And then they'll let you know. Okay? Some of us are fortunate enough we have children who let us know now. But premature death. What if your child dies before you do? I know it's not supposed to happen, but it does. And we deal with clients this happen every day. Okay? Now who owns your house? Your son-in-law or daughter-in-law? Because if your kids have a will, what does it say? I leave everything to my spouse. Right? They don't have a will and they have kids, it's going to be split between the spouse and the kids. So now your grandkids own your house. What if they're not 18? Oh, we got to get a judge involved because they need a guardian because they can't own real property. Had this happen, fortunately, the kids were 17 3/4. And I didn't do the deed. I said, listen, here's what we got to do. We'll wait till they're 18. We'll file the appropriate paperwork in probate court, and your kids can sign off that you can have the house. But if they were 15, we might have had a different problem. Because a judge can't approve the kids giving away an asset. They got to get paid for it. What if none of that happens and everybody agrees to sell the house? You're going to downsize and move to Florida like a good New Yorker. Okay? Everybody know what capital gains tax is? You buy low, sell high, you got to pay Uncle Sam because you're smart. Right? And as a homeowner, when you sell your primary residence, you don't owe capital gains tax, right? Everybody with me on that? As long as you live there 2 out of the preceding 5 years, you don't owe any taxes. Up to a certain threshold. I think it's like $800,000 or $600,000. Well, the problem is that's not your kid's house. Not their primary residence. So they owe capital gains tax. Right? You gave them the deed. Yes, with me? You reserved a very small portion of that deed from a tax standpoint. That portion is based upon your age and your life expectancy. The older you are, the less you own from a tax perspective. So now your kids have to pay capital gains tax on their share of the house. Folks became clients of ours. This happened to them. The 2 kids had to each pay $7,500 in capital gains tax on the sale of the house that wasn't even really theirs. But mom and dad lost out, right? Because that money would have gone to mom and dad free and clear of taxes had mom and dad done a planning. Can you see why I don't really like this giving the house to the kids thing? What if your kids have creditors and they have a judgment? Who gets paid when the house gets sold? Right? So we have one of the premier debtor, creditor, and corporate attorneys back here, Frank Daviano, right? Who gets paid, right, Frank? The secured creditor. The attorney won't let his client buy the house unless this closing attorney makes sure the creditor is paid and you get a release. You say, John, I would never give my house to the kids if they had a judgment against them. And I would challenge you that, first of all, you would never ask that question in polite company. Okay, it could be uncomfortable. Maybe the kids forgot. Maybe they're not going to tell you. But what if your kids get a creditor after you give them the house? They get divorced and nobody pays the bills. They lose their job through no fault of their own and they can't pay their bills. Okay, they have an accident and there's not enough insurance to cover things. Okay? All these things can go wrong. And if none of that goes wrong, you may have screwed up financial aid for your grandkids. Because some colleges, and I actually researched this a little bit, the FAFSA form requires you to list this type of property on the child's financial aid form. That's an extra asset. So, questions on that stuff? All right. So, how many folks want to lose control of their house? Nobody? All right. So, if you don't care about control, we'll do a deed to the house. We have you sign a disclaimer in our office that we told you all these things. Okay. Oh, the one thing I didn't tell you. This is interesting. Let's say you did a deed to the house to the kids, life use to you, and you go into a nursing home. You get on Medicaid. The kids say, we can't pay the carrying costs for this house. It's too much. We don't want to take care of it. We're going to sell it. Okay. Not only they're going to have to pay tax on their capital gains portion, but because you own life use, you're going to get some money, and that's going to go to Medicaid. Okay. So if we want to stay in control and not have all those problems, then we need to find a different solution. This is part 1 of our decision tree. We're going to go through this at the end. Right? So, how many folks here have an estate plan? Everybody should raise their hands because you have an estate plan by default. Okay? Kind of getting the theme here, right? Okay. New York State says if you pass away without a will, and you own property solely in your name, not a joint owner, no beneficiaries. It's usually the second of a married couple this happens to them. This is who gets your stuff. If you're married and only married, it's your spouse. If you're married with children, your spouse gets half, your kids get half, but your spouse actually gets the first $50,000. If you're not married but you have kids, your kids split evenly. If one of your kids died before you did and they have kids, those grandchildren of yours take what would have been their parents' share. If you have none of those, do you have parents who are alive? If yes, the parents get it. If not, then it goes to brothers and sisters. And if they're deceased, it goes to nieces and nephews. If you don't have brothers or sisters, we go to cousins, aunts and uncles. I think our farthest one out was second cousin twice removed. And one of our team members went down to the Church of Latter-day Saints to do their genealogy library to find the person. Okay? Those are the people who are required to have notice, and they would inherit from you when you die. So everybody has a plan. But the law allows you to make your own plan. Okay? And most people do that with a will. Okay? But I want to get back to, we talked about gifting, a couple points. Number one, not only don't I like people to gift their house away, I don't like you to put your kids' names on your bank accounts. Okay? Because if your kid has a creditor and their name's on your account, who can get your money? The creditor, right? Because if your child can take the money out, does everybody agree if you put your child's name on your bank account, they can take money out of your bank account whenever they want to? Right? And I know Fred and Bonnie's kids would never do that, but other people's children might. Okay? So we want you to have a power of attorney. The power of attorney says to your children, whoever you choose, listen, you can use my bank account for my benefit to pay my bills or at my direction, but it's not your money. It's still my money. One of the issues with powers of attorney are, however, that they end when you die. Right? Some people think, oh, power of attorney, they can take care of my estate. No, they cannot. Your power of attorney ends when you die. Okay? So most people then turn to a will. But a will is the straw house of the three little pigs. A will's worth nothing when it comes to creditors. As a matter of fact, wills are not even used until you're dead. How many folks here have a will? How many have used it? Right? Sitting in the lawyer's office. That's part of the lawyer's retirement plan. They hold your original will hostage in hopes that the kids will come back to them for probate. We don't do that. Lorraine just started with us. She's our probate paralegal. I think you were shocked when we said we don't keep the original documents, right, Lorraine? She's been in the business 20 years. Started when she was like 6. Okay? Prodigy. She's a prodigy. Okay? For 3 reasons. Number one, I don't want to pay the storage to store the wills. Okay? Number 2, I don't want the liability if something happens to your will. And number 3, and we believe this, we preach this, and we try to practice this way. If we do a really good job for you, you will tell your kids, when time comes, go to Safe Harbor Wills and Trusts. They were great. Okay? We shouldn't have to hold your documents hostage for your children to want to work with us to wrap things up. Because if you're in our annual client care program, we'll make sure your assets are aligned, your documents are aligned, so that everything works smoothly for your kids. Why would they go anyplace else? Especially with internet, Zoom, Skype, all that stuff, we can do stuff online. Okay? So, the will only works for property that is in the name of the deceased. Okay? So, before they were deceased, all the assets were in their name, which means they can get it, and if the client can get it, their creditors can get it, right? So wills only work for what you own, but if you own stuff, then your creditors can get it. And wills are not valid until they're authenticated by a judge. This is the one that people just have a hard time with. I guess I get it. Well, this is my mom's will, I get everything. No. We have to submit it to the surrogate court for the judge to approve it. Why does the judge get to approve my mom's will? Well, it's not really the content of the will, it's whether or not the will was done correctly. This lady just came into my office, I think Tuesday. So, well, I have my sister's death certificate. I have her will where she named me the executor. Oh, great, let me see the will. This is fantastic, because a lot of times we got to fish around for the will. It was a one-page, not even 8.5 by 11, like notepad paper, handwritten, allegedly signed by her, notarized, with no witnesses. I said, that's not a will. That's not going to stand up in court. You have to have 2 witnesses. Okay. And now it's going to be sister had no spouse, no parents, no kids. Now we got 4 siblings, 2 of whom have died. We got to track down the nieces and nephews, some of whom hate my client. Okay? It's a disaster. Okay? But that's the process. And the nieces and nephews who the deceased did not want to inherit have to be put on notice that their aunt had died and this is going through probate and they're entitled to a share of the estate because she didn't do it the right way. The other thing is when your kids use your will, they're going to get a bill. There's court costs. You have to pay a filing fee just to use the court. One would think your taxes would take care of that, but evidently they don't. Usually you pay a lawyer. If it's a contentious estate, you might have to get an appraisal. The executor is entitled to be paid commissions. Okay? On average, estates cost across the country about 3 to 7% of the gross value of the estate. Some things aren't part of the estate. Life insurance is not part of the estate, assuming it's done right. IRAs, 401ks are not part of the estate. Okay? So wills will actually wind up costing you far more money than other planning we're going to talk about. So this is a relatively modern estate. 5% of that is $20,000. Even if it's half of that at $10,000, that's a lot of money. Now, the good news is, I don't know if it's good news, when your kids pay this, you'll be gone. So you don't even know what's happening, right? But your kids are going to get far less money. The estate has to stay open for 7 months so creditors can file any claims. So it's kind of stagnant. There's a big rush, and it's stagnant for 7 months. Then there's a big rush to close out the estate. And I never would have thought I had to say this until this year. We went 10 weeks where we couldn't file anything with the court because the courts were shut down. You couldn't even e-file. I think we stacked up probate cases. How many, Lorraine? That we couldn't even file. And I understand why the courts didn't want to e-file, because when the workers came back to work, the whole system would be full of cases, right? So that was a unique experience. I don't know if anybody ever anticipated that. You know, even at 9/11, I was in the middle of a trial at 9/11. I think we missed a day and a half. I mean, we weren't in New York, so that was different. We were up in Oswego County. Okay. All right, so here's what we charge. One of the things, we believe in being very transparent with everybody, okay? We're going to tell you our fees. Our fees are fixed for this type of planning. The only time I charge by the hour is if I have to go to court, because I don't control that time. Base will is $500 or $750. A standard will is $850 to $1,100. Right? But the tail end, your kid's got to pay probate. So what's the difference between a base and a standard? I'm going to talk about a little bit more. A base is, hey, I'm dead. Here you go, here you go, here you go. Okay, there's your money. You're on your own. A standard is, you know what, I have some concerns. I'm worried about my child's marriage. I have a child who's terrible with money. He's got creditors. I have a grandchild or a child maybe with special needs. I want to protect what I leave them after I'm gone. So that involves a whole other level of planning, and we'll talk about that. That's the difference between the base and the standard for us. And that's an individual choice. Okay. All right, so on page 16, we do a chart here, a spreadsheet of the 3 different plans we're going to talk about. So you guys can go through that at your leisure. And we're going to come back to that at the end a little bit. All right? But everybody's pretty familiar with wills. So any questions on wills? Everybody understand they don't protect your stuff and why? Right? We had a pretty good show of hands for people who have wills, right, that are here. But you're all here because you're worried about losing your stuff to a nursing home. So intuitively you know that a will doesn't protect your stuff. And you might not have known that it's just going to cost money at the end. That's why wills are so cheap. All right. So we already know we want to stay in control of our stuff. How many people think it's a really great idea to help your kids avoid probate? Show of hands. Okay? So if you don't care about probate, we do a will. If you do care, we got to find a different solution. All right, we're going to have a general discussion on trust, and then we're going to take a break. Because studies have shown listening to lawyers for more than roughly 60 minutes at a time can bring about catatosis, and we don't want that to happen. Okay? All right, trusts are great because trusts avoid probate and help you stay in control of your stuff. Okay? You stay in control now, you avoid probate when you die, and you plan for your heirs after death. In your trust, it will read very much like a will. When I'm dead, $5,000 goes to my church, $2,500 goes to the SPCA, $5,000 goes to the Jimmy Fund, or whatever you want to do. My granddaughters get my rings, my grandson gets my Lionel train set. My kids split everything else equally. Sounds a lot like a will, right? But it's within a trust. So all trusts have three things in common. Number one, the person creates the trust. We call them a grantor. Most people call them grantors. Some people call them trustors or trust makers. That's you. Okay, you're going to make up the rules to your trust. You're going to decide today, this is right for me or this is right for me. You're going to be referred to in your document as the grantor. You're the only one that can make the rules of the trust. You're the only one who can change the trust. I want you to be clear. It's not because you're you, it's because you're the grantor. Okay? And you're the only ones that can be the grantors of your trust. The trust manager, that's who runs the trust according to the rules of the grantor. While you're alive and well, you're going to be the trustee. Okay? When you're deceased, or if you become incompetent, you're going to name somebody else to be the trustee. We call them a successor trustee. We don't need the court to appoint the successor or trustee. We don't need the court to peruse the trust to make sure it was done right. It's none of the court's business. The successor trustee can only run the trust according to your rules. They can't change the trust. Why? Because they're not the grantor of the trust. And then you're going to decide who gets to use your stuff. While you're alive, you're the beneficiary of the trust. You get to live in your house. You get to paint it purple if you want to. You can play the stock market if you need to. Okay, you can take money from the trust and buy that boat you always wanted. When you're gone, you're going to decide who gets your stuff out of the trust. This is all done outside the purview of the court. So how do we make the trust work? Well, the trust has to own stuff. The trust does not work unless it owns things. And one of the biggest issues that we see and financial advisors see is, hey, you know what? The client never put anything in their trust they bought at ABC law firm. Okay? We always make sure your property goes into the trust, and we give you very specific directions on how to go to your financial advisor, how to go to your bank, how to go to your life insurance company and get things in the trust. Because if I went to your bank and said I need to move Fred's money, especially now when I got a mask on, oh man, they're going to lock me up and take me away, right? I can't do it, but we give you directions on how to do it. Actually, I had a very nice phone call with the bank the other day with our client was there. She said, I love this letter. This is great. We make it very easy. So to put things in the trust, we have to change the name on the title, whatever that title is to that property. With a house, it's a deed, okay? Called an indenture that goes back to ancient England, okay? So John and Abigail Adams knew something was coming up around July 4th, so they decided we're going to set up a trust, the Adams Revolutionary Trust, and we're going to transfer our house into that trust. So the owner no longer is John and Abigail Adams, it's John and Abigail Adams as the trustees of the Adams Revolutionary Trust. Okay? They're really the safeguard of that trust property. Okay? And their job is to keep it safe for the beneficiaries of the trust. Okay? And they file that, and now their trust owns the property. Anybody here still follow the real estate section on Sundays? No? Everybody's gotten away from that? You see trusts in there all the time, right? Okay. If you get up north on the river, on the lake, you'll see trusts all the time. So, let's say you want to sell your house. You're the trustee of your trust. Here's your home, and you find a buyer. Okay? Well, the buyer gives you a check, right? Who's the check made out to? You or the trust? The trust, because the trust owns it, right? Now the trust owns the money. And you go down to Florida and you find a nice place and you want to buy a new home. As the trustee of the trust, okay, you write a check from the trust to the seller, and the seller does a new deed. Who's the deed made out to? The trust, right? Because the trust had the cash. The trust is buying the property. In the Medicaid creditor world, as long as you buy and sell directly from the trust, none of that money ever left the trust. We're just exchanging one asset for the other. Okay? People make a mistake. Oh, I have to take money out to me and then buy the house and put it in the trust. No. The trust is a legal entity. It can buy and sell things. Think of Wegmans. Danny Wegman doesn't take money out of Wegmans to go buy the next plot of land for a store and then give it back to Wegmans. Wegmans writes a check. The deed is made out to Wegmans. And then he builds his next store. Trusts are very similar to, there are some differences, but for most folks it's easy. Just think of it as you're setting up your own company and you're going to be the president, and when you're deceased you have a succession plan in place. Okay? And we're either going to blow up the company after you're gone and split everything and just shell out the money, or maybe we split it up into different companies for each of your kids, and they can be in charge of their own little company. Okay? All right, so let's take a break. If anybody knows today their appointment doesn't work, you can see Ann or I think Hannah out front. They have our calendar open. They're bringing refreshments back at 5, Marie? Is that correct? Okay. Restrooms out here to the right. Let's get back here in 10 minutes. Is that fair for everybody? About 10 after? Okay. Anybody here watch the local show or listen to the local show on WSYR? There's one of the stars, Steve Roberts. Say hi, Steve. Hi, Steve. So evidently Tom was too busy. He was our first choice. All right, we'll see everybody back here about 10 after 5. Get some coffee. Get Rejuvenol because you're a good New Yorker. So we're going to talk about a couple different types of trusts. Revocable trusts are pretty much the same everywhere. All right. The irrevocable asset protection trust we're going to talk about, depending on the state, will probably need some tweaks, but they're pretty much statewide or countrywide, other than Nebraska. There's a weird constitutional thing in Nebraska about why they don't work. So what we've done before is I'm a member of a couple national organizations. We find you an attorney that does what we do the way we do it in that state. It may not be close, but at least it's in that state. Okay? Massachusetts, I will tell you, is crazy. Florida is pretty much in line with New York. Okay. Won't be Florida? Too hot, Ginny, or too many people? My wife and I like Utah. Anybody been to Utah? Utah is beautiful. Except they tax your Social Security benefits. Okay. Yeah, in Utah. All right. So a couple things. Now, we haven't done this for 6 months, so I'm a little out of practice. So this should have come when we were talking about gifting, but I'm going to step back and talk about gifting because it's going to be important when we also talk about trusts. Okay? Gifting is really misunderstood. We often get the question, but John, if I give my kids money, are they going to have to pay taxes? The answer is no. Okay? It's wholly no. Here's why. If there is a gift, this is not compensation. You're not paying them to paint the house, okay? It's not prize money they won in a contest. This is a gift. It is the giver of the gift, not the receiver who pays the taxes. It is the giver of the gift, not the receiver. Now, gift tax is a federal tax, not a tax in New York State. So if you give money while you're alive, you only have to worry about federal gift tax, not New York State gift tax. And gift tax and estate tax is really a transfer tax. I forgot my S. When we transfer assets to somebody else, that can be a taxable event. It is not taxable between spouses, but anybody else, it's a taxable event, unless you fall under the tax threshold. Currently, the tax threshold is $11,500,000 each per person. Okay? So a big sigh of relief. How many of you just got under that? Right? Okay. Now, caveat, subject to change starting January 1st, depending on what happens November 3rd, right? So, if side A wins, there'll probably be a change. If side B wins, there may or may not be a change depending on who has Congress. Okay? So right now it's 11.5 million. Where people get misunderstand things is generally people know there's an amount of money that you can give away every year and the IRS doesn't care. They say, well, I can give away $15,000 and not pay taxes. No, you can give away $11.5 million and not pay taxes. You can give away $15,000 or less and not tell Uncle Sam. The $15,000 is merely a reporting threshold. It is not a tax-paying threshold. Okay? So if you were to give your kids $500,000 to start a business, you would tell Uncle Sam and say, listen, I don't want to pay tax on this, because I can still give away $11 million before I have to pay tax. I'm just telling you so you can keep track. When I die, you'll know I can only give away $11 million, but I only have $500,000, so I don't really care. Okay? If you give someone $15,000 or less in any one calendar year, you don't even have to tell Uncle Sam. Okay? So we're not worried about estate taxes and we're not worried about gift taxes. What we're worried about is Medicaid, because that's $12,000 a month, or nursing homes, $12,000 a month. So I don't want you to worry about gift taxes or estate taxes. Revocable trusts. Okay, we're going to talk about two types of trusts. There are many, 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 many types of trusts out there. It all depends on what you want to accomplish. We used to, when we did this, we talked about trusts are like cars. Tell me what you want to accomplish, and I'll tell you what kind of car you need. If you're going to take your 28-foot pontoon boat up to the Adirondacks with your 4 kids, your wife, your mother-in-law, 2 dogs, you probably don't need a Ford Fiesta. Right? But if you're going to go cross country, it's just you and a little dog, maybe a Prius. You don't necessarily need a big SUV. Depends on what you want. That's the type of trust you need. We're going to talk about 2, revocable and irrevocable asset protection trust. This is on page 10 of your booklet. Revocable trusts are very easy to understand, so we don't really spend a ton of time on them. Okay? There's no protection from creditors. A revocable trust by its terms is revocable. It's built right into the document that says you as the grantors may revoke this trust at any time and return the assets to yourselves. That means you can get it. And if you can get it, they can get it, right? You can get it, they can get it. Okay? There are no changes to your taxes, either income or property. The IRS says, really, for IRS purposes, this trust doesn't exist. For Medicaid purposes, the trust doesn't exist as if it's not there because you have total control, total access, and can return the assets to you at any time and spend those assets on anything you want, including nursing homes. So, how does a revocable trust work? Once we create the trust, we then have to put our assets into the trust. The only assets that go into the trust are those that don't have beneficiaries. Because the only purpose of a revocable trust is to avoid probate. And assets with beneficiaries avoid probate automatically. Right? So I put them in the trust. Why go through that hassle? Right? Not that it's a big hassle. Now, you also notice IRA 401k. The second reason we don't put those into a trust is the IRS says we can't. Retirement accounts have to be owned outside of trusts. IRAs have to be owned by individuals. 401ks are owned by companies. Right? 457s, 403bs, those are owned by the state. Okay? And in the nursing home Medicaid world, we talked about this a little bit, once you're taking your required distributions, the balance of those accounts are protected from Medicaid. Okay? Now, interestingly, if you're not on Medicaid, the nursing home is going to say, well, empty that 401k and pay us. So it really makes you money to get on Medicaid because Medicaid will protect your IRA. Okay? Medicaid only says we got to take the income, we're going to ignore the money in the account. So there is no limitation on what you can spend your money in the revocable trust on. Travel, vacations, bills, groceries, medical bills, go to the casino, lose $500 at Del Lago, go take $1,000 out, go to Turning Stone because your luck's going to change. Okay? Whatever it is that you want to do, you can spend that money. So there's no restriction, so there's no protection, right? Because if you can get it, they can get it. You can get it, they can get it. Now this even applies that you can get it, they can get it. Anybody have a 529 plan for the grandkids? Okay, you have any accounts that are in trust for your kids or your grandkids? Right? If you did, those are still your accounts. They just go to somebody else when you die. It's still your money. So once you pass away, the trust is still in existence. The trust doesn't end when you end. The trust ends when the assets are distributed out of the trust. Okay? And that will be done by your successor trustee, who you name in the trust. So because the owner of the assets is still alive, we don't need to go through probate because assets only go through probate when there's no living owner. Okay? And technically, under the law, the trust is still alive, it's still viable, it's still in place. So the assets are not ownerless. The owner is the trust. The trust just has a new boss. Okay? And that new boss has to follow your rules. We settle trusts in our conference room, not in the courtroom. Okay? So some advantages of trust. Well, if the courts ever get closed again for 10 weeks, doesn't stop us from taking care of a trust if you pass away. If you've disinherited a child and you don't want them to have a notice that they've been disinherited because they had to get a copy of your will, we don't have to give them a copy of your trust. They're not a person who's getting something in your trust. Okay? That is a very state-specific rule, to go back to the question about changing states. Okay? New York does not require you to give a copy of the trust to someone who is left out of the trust. Trust will eventually save you money. Okay? If you remember back to our probate case, we have the base and the standard revocable trust. Now, how we get paid is 10% down, and then we have a 4-step process, and we get paid at each part of the process. We don't ask you to write a check all at once. We don't want to get paid till we get the work done. The 10% is this is good faith, we're going forward, moving along. Okay? And again, on page 16, we have this work spreadsheet. Notice up at top, we have done nothing to impact the Medicaid 5-year rule because the money in the trust is still ours. Okay? Up there, you'll notice I call it the look forward. The look back starts when we're in the nursing home. And right now, nobody has any idea when their look back is going to start because nobody knows when they're going to go in a nursing home or if they're going to go in a nursing home. Right? And we control when we start the look back because that starts when we're in a nursing home and we ask for Medicaid assistance. So our 5 years might be 15 years because we might not be in a nursing home for 15 years. What you can do by being proactive is say, I don't want that. I want to limit my time. I'm going to start my personal 5-year clock running. I'm going to get my stuff in a trust now, and I know that 60 months from now, even if there's a 5-year, 10-year, 7-year look-back period, my stuff is protected because I set my own 5-year clock. I didn't wait till something happened. I was aggressive, and I took care of this. Now, the revocable trust doesn't do that. I just want you to understand why we're doing the look forward. I get my plan in place now, and I can look forward for 5 years from now. Everything's solid, everything's protected. All right, any questions on revocable trust? Yes? Oh, is there a typo in the book? What's it say in the book? On page 16? On page 16? Right. But go look at page 16. Right. What's on page 16? Oh, you know what? They just reprinted stuff. They might have printed a different one. Excuse me. Oh, 14. It got moved. Somehow they got moved. It should be page 14. The book I looked at was page 14. I apologize. You're the first person in 3 hours to bring that up. I appreciate it. No, and I mean that. I appreciate it. Okay? No, that's our mistake. Yep. Right, there's no impact. The look back, the look forward are the same thing, just depends on how you look at it. Yep, that's okay. Yep. Okay. Thank you. All right, other questions? Okay. So do you understand, and what's your name, ma'am? I can't read back that far. Jean. So it's just a question of perspective on the 5-year rule. Technically, the look back does not begin until you're in a nursing home. And then once you ask for Medicaid, they're going to look back 5 years. The different perspective is I'm not in a nursing home. I want to get my plan in place and start a 5-year look ahead. Yep. So, all right. But, and that's why it shouldn't be inconsistent, but it's different sides of the same coin. Does that make sense? It's all perspective. Okay. You want to keep control, right? We already decided that. We want to avoid probate. Do we want to protect our assets? If you say, you know what, I'm not really concerned. I've got great long-term care. I got $400 a day. I'm making $4,000. I'm never going to get Medicaid. Maybe the revocable trust is for you. Okay? But if not, then we got to find a different solution to protect our assets. All right, irrevocable asset protection trust. Here's what I want you to know. In New York State, irrevocable does not mean what you think it means. Anybody a fan of The Princess Bride? The movie? Anybody know the movie, The Princess Bride? Really? I do not think that word means what you think it means. New York State says, if you have an irrevocable trust, and you have beneficiaries who are usually what? Your kids, right? As long as your beneficiaries agree with you, you may revoke an irrevocable trust. You can revoke an irrevocable trust as long as your beneficiaries consent. Okay? I call it the Bill Clinton rule. Depends on what your definition of irrevocable is. Okay? So let's imagine you have a trust and you have 2 kids. Okay? They're your beneficiaries. New York State says, listen, you and the kids are the only ones affected by this trust. If you all agree that it can be revoked, then go ahead and revoke it. We don't care. As long as all the people who are affected by the trust agree, then go ahead and do it. Right? The revocable trust says we don't need the kids, okay? Because we built into the terms that we as the grantors can revoke it without anybody's consent. The reason this is different, not to go all legal technical on you, is the law says these kids have a vested future interest in the trust because it's irrevocable, and at some point in time, we don't know when, they're going to get money. So they're an interested party now. As long as they agree, okay, we can revoke it. So a lot of people get caught up, oh, this is irrevocable. Oh, I don't want to do anything. Okay? Don't worry about it. Now, this trust is just like any other trust. You have a grantor, a trustee, and beneficiaries. But it's the brick house. It's going to stand up to creditors. For Medicaid, it just takes 5 years for the mortar to harden. Okay? But any other creditor, it's good right away. Not any future creditors, but any creditors, not any current creditors, but any future creditors. I can't put your stuff in the trust if you came in and said, John, you know, last night I hit a bus full of nuns. I'm afraid I'm going to get sued. Okay? Frank, that would not stand up, would it? No, Frank does a lot of creditor-debtor stuff. But if a year ago I put my stuff in a trust and I hit a bus full of nuns, right, we'd be good. Okay? So, you know, just diary the bus full of nun stuff and then do your trust before that. All right. So the key with this trust is, unlike the revocable trust, we're not going to put all your money into the asset protection trust. The money you need to live on, the money that gives you comfort, okay, stays to the left. Your Social Security doesn't go into the trust, it can't. Your pension doesn't go into the trust, it can't. Your IRAs can't go into the trust. But they're already protected from Medicaid once we're doing the required minimum distributions, right? So we're good with that. What do you need in the bank account to live your life? And I get this all the time. Well, you know, I was thinking of buying my whole family a round-the-world cruise first class. How long are you thinking about that? 25 years. What if I need the money? Well, you won't need the money. How do I know you won't need the money? Because you have the money. Okay? People who have saved and saved and saved don't suddenly become spenders. It just doesn't happen. Okay? So we take the money that you want to be your legacy, that you want to make sure your children have, your grandchildren, your charitable bequest, whatever that is, that you say, listen, in an ideal world, I'll have my money to spend, do whatever I want to do. This goes to the people I love. And I don't want to lose it to a nursing home or anybody else. My house, my camp, my investments, whatever that is for you. We take that and we sock it away. The rest is you keep living your life. We never want to do a plan that negatively impacts your lifestyle. Okay. Now, there's also been some changes in the tax law where if you need extra money, we're going to want you to take it out of your retirement account rather than any place else. Because when it goes to your kids, they're going to pay more taxes on that money than you are, almost always. So it's better for you to spend it. I promise you, the way we plan, you will have enough money to live your life. The only thing you won't have is enough money to pay the nursing home for 3 years. Okay? We want to protect that money. So there are limitations on this trust. Remember the revocable trust, there were no limitations, right? You can't spend this money on you. That's what this money's for. Okay? Oop. That's what this money's for, over here. That's to go out to dinner. That's to go to shows. That's to give money to your grandkids for Christmas and those types of things. You can't buy your groceries. You can't pay your National Grid bill. You don't take vacations with it. Okay? You can't pay your medical costs, including nursing homes. That's how this is protected. Okay? And when you pass away, everything goes to your heirs outside of probate. So, this is either on page 16 or 14. I apologize. Okay? All right. I think I looked at an older book, Marie. I apologize. The big book with the big one with everybody, with all three things on it? 14, right? So let's go to 14. Okay. Just so you can see it across the board. So this is total creditor protection and starts our 5-year period running, right? Because we've given it away and we can't get it back and we can't spend it on our creditors. So for Medicaid purposes, we gave that money away. You're going to be the trustee of the trust. You have total control. You can modify the trust sum. What do I mean by that? If one of your kids goes off the reservation and they're not talking to you anymore, you can remove them as a beneficiary. Okay? If your daughter invents the next internet equivalent, becomes a gazillionaire, okay, she doesn't need your money. You can take her out of the trust or make sure she gets less. You can change who your trustees are. Okay? If you want to add a charity, you can add a charity. Okay? You can even revoke the trust with the consent of the beneficiaries. But what if one of your 2 kids won't agree with you to revoke the trust? We can modify the trust. We can remove them as a beneficiary. Therefore, we no longer need their consent. Okay? Real life example this year. Had a client about 2-3 years ago, did a trust. Everything was going to go to his nephew. One of his nephews, not his only nephew. Had no spouse, had no kids. He and his nephew had a falling out. He said, John, I'm going to sell my house. I'm going to move into an apartment, and I don't care what's left for anybody. Okay. I said, will your nephew agree to revoke the trust? He said, absolutely not. We're not talking. He wouldn't do anything to help me. And I'm not going to ask him. I said, okay. Do you have a friend that you trust? Yes, I do. All right, why don't you come in on this date and we'll take care of it. So what we did is we removed the nephew as a beneficiary of the trust. We installed his friend as the beneficiary of the trust. And then his friend signed a consent form that we could revoke the trust. Okay? He then went to the closing, sold the house, all the money went to him, and then we did a new will and healthcare proxies, stuff like that, because he had to remove the nephew. Okay? So the point is, you're not locked in just because it's an irrevocable trust. Okay? There are things that can be done. Okay? You get to use it a little bit. So if you want to put a roof on the house, if you want to buy furniture, if you want to invest in stocks and bonds, if you want to buy a boat, things like that, the trust can do all of that stuff. The trust says, listen, we can never give money back to mom or dad or their creditors, but we can give it to our kids, okay, while we're alive. So if you need money out of the trust, you give it to the kids, they give it back to you. Or they spend it for you. And what if you give Jimmy $10,000 and he doesn't go and buy the trip for you, but he goes and buys himself a Harley? Well, we're stuck, right? Jimmy gets to keep the Harley because the $10,000 was a gift. But we're going to go back to Safe Harbor Wills and Trusts, and what are we going to do? kick them out of the trust, right? We call that the don't mess with me clause. One of the things we invite all of our clients to do is either in person or a Zoom call or a conference call. Bring your kids in if that's important to you at the process at the end, and we'll walk them through what we've done, why we've done it, how it works. You're doing this for them, right? You're not here because you didn't have anything better to do. Well, maybe with this environment, but okay. This is for them, so let's bring them in, let everybody be on the same page, understand what's going on. Okay. The IRS, because we have all these controls, says, you know what? You don't have to pay any trust income tax. Everything's going to be taxed to your personal account. Because you're the trustee, you can make changes. Because of all these rules, the IRS says, you know what, that's really your money. You're not fooling anybody. Okay? But Medicaid says it's not your money, you gave it away, you can't use it for nursing homes, therefore you're going to get qualified for Medicaid more quickly. And it works just like a will, and it avoids probate. So let's look at all the other stuff that we have looked at so far, the total cost here. This is what our trust costs, $49.50 for the base, which says when we're dead and gone, here kids, take your money and run, and $64.50, about 1/2 of 1 month in a nursing home for our standard plan, which is not 1, not 2, but 3 generations of asset protection. Okay? And again, we get 10% down and spread it out over your appointments. Any questions on the asset protection trust? Awesome. All right. Either a good crowd or I bored you to death. Okay. So depending on if we want asset protection or not, we're going to decide which type of trust we have. Okay. Why plan now? If I say you're grandfathered in, what does that mean to everybody? Some rule has changed, but you're under the old rules, right? Okay. I am of a personal belief that due to all this spending that the government is doing, at some point someone's going to stick in an extended look-back period to try to recoup some money. That's personal belief. I believe it's very well founded. In 2012, a congressman did try to have a 10-year look-back period put in place, but it never got out of committee. New York State just added a 30-month look-back period for community Medicaid that wasn't there before. This would have to be done at a federal level, depending on who wins. You know, it's a budget crunch, so that's an easy fix. Nobody's going to be upset, okay, because Mary Beth had to pay for a nursing home instead of protecting her money, okay? So that's an easy one. The middle class is an easy score, and how dare you protect what you've worked so hard for, okay? So that other people who didn't save, who didn't earn, who didn't protect, who didn't do the right things get stuff for free, but you should pay for it. Okay? So we like the grandfather clock because you start the 5-year clock running when you plan and you're grandfathered into the current rules. Okay? This is a picture I got from a client of ours up in the Canton area. She sent this to me with a thank you note. She said, John, this is our neighbor's house. It was just sold at auction to pay for long-term care. And I was talking to the son who said, you know, we tried to get mom to do something and she just didn't believe somebody could take her house just because she got sick. And here we are. And if you look really hard, you can see the St. Lawrence River between the right corner of the house and the tree. The house on the St. Lawrence River up in Canton. And our client was very appreciative of where they were in the process. Okay, so let's move on to the next one. Now you got me all worried. I don't have the right pages. Protection for your home and your family heirs, okay? So what a lot of people do, what most estate plans do, is say, listen, kids, we're dead. Here's our money. You have all these risks in your life. See if you do as well as we did. All these things can happen and money can be taken from your children. What you're really doing is just recycling risk. You're asking them to run the same race, and hopefully they'll turn out with as much money. 70% of the time, family assets are lost in the first generation, and 90% of them are gone by the next generation. That's according to Kiplinger's. I love the title, 5 Strategies to Keep Your Heirs from Blowing Their Inheritance. This is my favorite one, though, from Reuters. It takes a third generation, grandkids, average of 19 days from getting their inheritance till they buy a car. Okay? So we developed a strategy we call the family prenup. Okay? You can protect your money for your kids and for your grandkids. You're not controlling it, you're protecting it. Right? And it's something only you can do with your money effectively. Okay? So this is my parents' plan, me and my sister and brother. Okay? And the asset protection not only starts when you get all your stuff into your trust, but when the first of you dies, if you're married, what if your spouse remarries? And what if their spouse goes into a nursing home? Who has to help support? You do, because it's your spouse. Okay? What if your spouse dies, leaving their new spouse behind? Who has a claim to their estate? The new wife. It's his wife. Remember the wife, you can't completely disinherit your wife, right? With a will? That was like 2 hours ago. Remember, Bob, Catherine, you can't totally disinherit your wife with a will? So even if my dad remarried, and he did a new will, says his wife gets nothing, guess what? She still gets a third. And even if they had a prenuptial agreement, if it was a nursing home, Medicaid wouldn't care. Medicaid didn't sign the prenuptial agreement. Okay? So what happens is this. If my dad gets remarried, his wife goes in a nursing home, the money in the trust is protected. If my dad gets remarried and he dies first, the money in the trust is protected. New wife can't get it. Okay? And when they're gone, their trust splits into 3 equal trusts for me, my brother, and sister. And we are each in charge of our own trust. And then when we're gone, whatever's left goes to each of our kids. My parents love my wife. They tolerate my son-in-law, or my brother-in-law. I kid. My brother-in-law is a great guy. And my brother Steve is just recently divorced. Okay? What my parents want to make sure happens is when I die, my sister dies, or Steve passes away, their money goes to their kids, not their in-laws. My dad told me many years ago, it's your job to take care of your wife, it's not my job. And I agree with that. Okay? Some people want to do it differently, that's okay. We usually have a sign a disclaimer if you're going to give money to your in-law. Because I don't want your grandkids suing me because your daughter-in-law's new husband spent all of their inheritance. See, people don't think about their daughter-in-law or son-in-law getting remarried after their child dies. Guess what? It happens all the time. And all those same rules about your spouse getting money, or if they do a new will, I leave everything to my spouse, those all apply. Okay? And then my parents have decided they don't want the grandkids to get their grubby little hands on the money until they're 30. So my brother's much younger than I am. So Jack and Eva are much younger than all these kids. So if my brother dies first, Aunt Mary and Uncle John are in charge of the money for Jack and Eva. They want to go to school, trade school, college, they want to start a business, up to us how to spend the money. Okay? If it's a good idea, we'll spend the money. If it's a bad idea, Uncle John, I want to go to Europe and find myself. No, find yourself a job. Okay? To be fair, probably one of the things to keep with my parents' tradition is the kids raise half the money, we would help them out with half because we're very big on travel. Okay? So we can do this family prenup with a will or with a trust. It can be built in. That's the difference between the base and the standard, is this planning for your family after you're gone. Okay? It can be done in any place. Just the only way we know that there's actually going to be money there to do what you want is here. Because we protected it from probate, we protected it from nursing homes, which these do not do. All right, questions on that stuff? Boy, quiet crowd. Were the cookies really heavy sugar or what? Were they? I would tell you, we do 2 annual client events for the people in our care program. One here and one at the Harbor Hotel in Clayton, because we have an office in Watertown. These folks do a great job. The food is really good. When they're open again, if you just need a different place to go to dinner, the place is really good. Did they? So before our last one, Marie and I, just you and me, or did Anju come to the testing? Yeah, they gave us the chef brought out like 5 dishes that we could try. Yeah. All right. So there's no questions. Now we're going to design our plan. So go to the back of your book, not the back page, but the inside back page. Everybody there? Page look like this? Yes? Everybody got their pen in hand? All right. Do we want to stay in control of our stuff? If it's no, check no. We'll do a deed. We'll know what you want to do when you come in to meet with your case manager. If yes, you want to stay in control of your deed, check yes. Now the next question is, do you want to avoid probate? If we don't care about probate, check no. If you want, and we'll do a will. If you do want to avoid probate, check yes. And we know you're going to need a trust. Okay? Everybody caught up? All right. So now the next question is, do I want a trust that protects my assets, or do I not care about asset protection? If you don't care about asset protection, you check no, and we'll do a revocable trust. Check yes. If you do want to protect your assets, we need an asset protection trust. Those of you with long-term care, probably check both, and we'll run the numbers and see which one makes sense for you. Okay. Everybody caught up? Okay. And the next question is, do we want to do the family prenup? Do we want to protect our money for our children and grandchildren so they don't lose it? Or, you know what the heck? We'll let them do their own stuff. Right? And there's not a right or wrong answer. Kind of what we like to do as a threshold is about $100,000, start really thinking about that family prenup. And that's for each child. Okay? Some folks have children or grandchildren with disabilities, so we'll definitely want to be down here because we can do a special needs trust that allow them to continue to get their benefits, but also to benefit from having that money set aside for them. Okay. All right. Any questions on that? No question. All right. Marie, I'm not seeing our quiz up here. Do you have an extra one over there? Okay. Everybody have their quiz? Did everybody go through the quiz at the beginning? Okay. I remember the first question. All right. That you don't need if you have a power of attorney, they can take care of your estate when you pass away. False, right? Okay. I don't know what happened. Somebody may have picked it up. I apologize. Can I ask somebody to read the questions to me? Fred, could you read the questions? Number 2. Everybody hear Fred? Primary concern should be estate taxes. True or false? False, right? We don't care about estate taxes. Fred, you want to do that again, if you don't mind?
I can give away up to $15,000 per year without any taxes.
True or false? False. Anybody know why it's false? Read the question again. Emphasis on any. I can give away up to $15,000 a year without any consequences. What if we have to go in a nursing home? And we gave away money in the last 5 years, right? We're going to have some trouble. Okay. Next question.
I have a last will and testament, my family will avoid probate.
True or false? False, right? Probate require, or wills require probate. Next question. True or false? False, right? Why is it false? Because we can avoid probate, right? Any part of a true-false question is false, the whole question is false. I remember because I went to school when they still taught logic. Next question, please. True or false? False, right? Next. That's false. Okay? What if I gave away my assets 10 years ago? So, whether or not you will be disqualified for Medicaid depends on when you gave away money, how much you gave away money, and who you gave it to. Okay? So, we had clients, they had one disabled child, wife was in a nursing home. She had $250,000. We gave it all away and got mom on Medicaid the next month. Why? Because she had a disabled child. Okay? Medicaid doesn't care if you give money to a disabled child. Okay? We have people who are what they call a caretaker child. They live in the house for 2 years prior to a parent needing nursing home care. We can give them the house without a penalty. So the 5-year rule is simply the look back. Whether or not you qualify for Medicaid depends on a lot of things. Too much to go into here. Okay? But the goal is we want to put your money away in a secure place to get our 5 years running so that when and if you need nursing home in the future, it's protected. Okay? Thank you, Fred. Could you continue, please? False. Everybody understand why that's false? Yep. Okay, next. False, right? Next. Thank you. Okay. If you've learned nothing else today, okay? I mean, in addition to the embassy has great cookies. Okay. Next. That's the community Medicaid we touched on. Okay? So if you get your assets in place, Medicaid has a program to help keep you out of a nursing home. Everybody see the PACE vans going around? Medicaid can pay for that. Nescentia, okay? Visiting nurses, all those things. Next. False, right? You're going to tell your friends that. They're going to tell you you're crazy. You just say, okay. I know something you don't know. All right? Next. True, right? Next. False. Why is that false? You know, it's one thing to memorize the answers, but if you don't know the theory behind it, because why Mary Beth was saying something. I'm sorry, was it Mary Beth? If Mary Beth can get it, they can get it, right? And it's revocable trust, so we can do whatever we want with it, including revoking it and returning it to us. Okay? Next. False, right? We'll use a power of attorney. Next. Yeah, our process, I don't think I went through that. We take about 6 to 10 weeks once you decide to move forward. So everybody here, I think everybody's appointments are within 30 days, right, Marie? So you could be done in 30 days plus 6 to 10 weeks, whatever that turns out to. Okay, next. True, right? 70%. Yep. True, right? Because the trust doesn't end when you die. So the assets still have an owner, which happens to be the trust, and only assets without an owner go through probate. Okay. Next. Probably not, but I will attempt to do so. Okay? Assets only go through probate when there's no owner alive or in place. Correct? When you die, your trust is still in place. The trust is the owner. So therefore, we don't need probate. You with me? Oh, that was just for this side of the room. No, just kidding. I think that's all I said. So. Next. True, right? Not taxes, long-term care. And it's only going to get worse because medicine keeps getting better, right? Keeps extending our lives. Okay, next. True, right? Okay. And now you can no longer procrastinate. Okay? Well, you can make a conscious decision not to do something. But you've been educated. You have a free appointment. That free appointment is going to result in 2, 3, 4, 5 meals being purchased for someone less fortunate. So if you make a decision not to come to your meeting, that's no longer procrastination. Okay, that's just a conscious choice. That's okay, that's your choice. Okay? But we've taken out all the roadblocks. All right? I love this quote by Martin Luther King Jr. You don't have to see the whole staircase, just take the next step. Come to your meeting, meet with your case manager. Be sure you bring in your booklet because you should have your plan all chosen in that booklet, okay? Don't procrastinate. The other thing I would ask of everybody, and I'm asking this as a courtesy. Obviously, we invest time here today. We have time in our calendar for all of you to get in as soon as practicable. If there's someone in your decision-making process besides you, please either bring them to the meeting and let us know, because if there's more than a couple of you, we'll change conference rooms just so we can socially distance. Okay, we try to be consistent with that. If they can only be available by phone or by video call, that's fine. It's not fair on our end if someone comes in and says, oh, I have to go talk to somebody else. Think about that today. Would you be comfortable going to somebody else and trying to relay to them what we discussed today as to why they need to do planning? Probably not, right? Would you feel confident in taking the answers from your consultation with the case manager and explaining everything you learned there and everything you learned today to somebody else who was not part of it in order to make a decision? So we just ask, have them available. If you need us to step out of the room so you can all talk, we'll step out of the room, that's fine. We encourage that. We have nothing to hide. We would just like the courtesy of everybody who's part of your decision-making process to be there at the meeting. Okay? And this is our process here. Just so you know, everything we do has a system, has a process. When you decide to go forward, we schedule all of your meetings so they don't get missed. I used to practice like this. I'm not blaming attorneys who do this. I used to do this. We'll call you when it's ready. No. Because then the next crisis hits, and the next crisis hits, and the next crisis hits. We schedule it out You'll know when it's going to be ready. For the most part, things happen in your life, things happen in our world. We may have to move the appointment, but it doesn't get forgotten. Okay? Our goal is to get it done for you. So, please fill out the evaluation thoroughly. Take your time. Let us know what you want to talk about at your meeting. Okay? Would you let us know somewhere on there how you heard about us? Dinosaur, Facebook, WSYR, maybe a current client of ours. And then hand your evaluation in to one of the team members. Are we exiting there or there, Marie? Okay. So everybody got that? If you're all set with your appointment, fill out your evaluation. You can hand those to Marie. And if you need to change your appointment, well, they can't change your appointment back there if you're there as well. Oh. They're outside. Okay. Out those doors to change your appointment. Okay? Well, you said I'm here. I'm back there. You said I'm back there. So, and on a personal note, I want to say thank you to all of you. This is a very trying time. Coming here today, I know this is important to you. I know my own dad is reticent to head out. So I appreciate it. My team appreciates it. And I hope it was a worthwhile experience to come here, that you learned a lot, and that you'll move forward and get the planning done to take care of your family. We're only here to help you. We can't do it for you, but we'll do it with you. Okay? Yep. Thank you very much. Really want to steal this. Bye, folks. We'll see you soon. Thank you.